motivating us to come up with new topics every week. As you all are aware that NACIN Mumbai has started this new online weekly series called the Vigilance Dialogues from Tuesday, June 18, and this is for 1.5 hour session. The purpose of this series is to bring awareness about vigilance matters, discuss issues related to it, and understand the working of vigilance machinery. Every week, a topic is being discussed, and so as to give space for question answers and taking up queries, and also to reach out to maximum people without disturbing their work schedule. The sessions are being conducted by Shri Prabhat Kumar along with other eminent faculties. Taking you through the memory lane, the inaugural session was on complaints handling and preliminary investigation, which was delivered by Prabhat sir. This was followed by next session on preparation of charge sheet and conduct of departmental inquiry, part 1. Third session was on conduct of departmental inquiry, delivered by Shri Surjit Singh, Director Retired CBC. And today's session is again on the conduct of departmental inquiry, part 3. Through these sessions, we tried to bring the insightful and informative knowledge to the participants, and the various aspects of the departmental inquiry and other aspects are being covered with the relevant example. Officers from Pan India are attending this interactive online session and are getting benefited from these sessions. Those who have joined today, I would encourage them to take full advantage of the valuable insights and knowledge being shared, and please ask questions. You can also put in the chat box, also mail us so that any small or big matter can be handled. And asking questions, seeking clarification, participating in discussions will not only enhance your learning experience, but also help us to add on to the topics. So it is also requested, if you feel that any particular topic is important or you want to discuss about it, please let us know. And with this, I welcome Prabhat sir once again, who has agreed to share his working experience with each of you, every one of you, through today's topic, conduct of departmental inquiry. And I'm very happy that sir has taken out time from his busy schedule and has planned to start this. So thank you, sir. And with this, I request sir to please start the session. Thank you. Over to you, sir.
Thank you, Jyoti. Thank you, Marietta, and very good morning to and welcome to all the participants today for the Vigilance Dialogue for today. So you all know that we have tried to create a kind of mechanism of sharing of knowledge and experience with everyone who has any kind of doubts or who are conducting the departmental inquiry and who wants to know about the vigilance domain much more deeply. So whatever experience we have in this domain area, so by myself and by the people who have worked with me or who are eminent personalities in this regard, we will try to rope them in and bring them on the platform to share their experiences and knowledge. But I will start the session again with that disclaimer that we always give, that this is only an informative session for a proper, you have to consult the proper rules whenever you really want to quote. Don't quote us out of the blue that in the Vigilance Dialogue we have been given advice like this. So this is the only disclaimer I want to put. And with this, let us start with the today's session. So in the last session, when Surjit Singh had taken, so he was delving into the departmental inquiries, how to conduct the departmental inquiries. He was talking about the appointment of IOs and POs. He was talking about the preliminary hearing and all. So I will take the session from there, that what should we do. So the preliminary hearing, if anybody has kindly mute yourself. If anybody has any issues that they want to ask question, because I want to have a dialogue kind of situation, so it should not be a monologue. So you can raise your hand in between also, and you can type the questions in the chat box. And later on, we will have enough time to address all kinds of queries and questions. We will not leave any question unanswered. That is the kind of assurance that I give you. So now let us start with the preliminary hearing. So whenever the IOs and POs are appointed and the IO's duty is to call the charge officer for the preliminary hearing. In the preliminary hearing, the basic thing is to decide or discuss like how this inquiry will be conducted and what are the documents made available to the charge officer, whether he wants the assistance of any defense assistant or not, and the timelines are discussed. And the time also is given to the charge officer so that he can come out with his defense witnesses, the list of defense witnesses, list of defense documents, whatever documents he wants. So, and also in the beginning of the preliminary hearing only, the IO asks the charge officer whether he agrees with any of the charges, active charges against him or not. So on his specific denial only, then the inquiry proceeds. If the charge officer accepts any of the charges unconditionally at this stage, then the IO will make a note of that in the daily order sheet, and then he will proceed with the other articles of charge. So the acceptance of any charge, any article of charge has to be completely unconditional, has to be completely without any kind of strings attached to it that since the department has not done this, done that, that is why I am accepting this charge, nothing of that sort. Then if there is any conditional acceptance of any charge, then it is better to go for the inquiry rather than accepting it as acceptance of the charge of this. So the practical advice will be like in the preliminary hearing, no charge officer accepts any charge. So it will be on IO to conduct inquiry in the entire article of charges, so the complete charge sheet will be inquired into. And the job of PO is very, very critical. PO is the person, the presenting officer is the person who has been appointed on the behalf of the department to put up the various facts before the inquiring authority and prove the charges. Let me tell you very categorically, the job of the PO is to advocate from the side of the department, from the disciplinary authority side, and to prove the charges. It is not open to the presenting officer that, okay, based upon the argument, it seems that the charges are not provable, so I am not including it as proof. PO has to conclusively prove the charges before the inquiring authority and also in the presenting officer's brief when the inquiry will be, but the oral inquiry ends. So PO will have to submit a brief. In that brief, PO has to conclusively prove all articles of charge. Sometime I have been asked this question, that is why I am stressing it, that whether PO can apply its mind and cannot prove the charges or disprove the charges. If any PO disproves any charge in his article, in his PO's brief, he can be also charge sheeted. So let us be very honest about that. So now, in the preliminary hearing, the inquiring authority asks the charge officer whether you have got the entire charge sheet, that means articles of charges, statement of imputation, list of documents, and list of the relied upon witnesses. Whether he has got all the statements of the witnesses, etc., etc. Whether he has got all the relied upon documents, copies. If not given to him along with the charge sheet, then the PO is directed that you fix up a time with the charge officer, and if he wants inspection of those documents, original documents, give the inspection of documents and supply a complete set of all these documents to the charge officer so that he can defend himself in this. So inspection of the relied upon documents is a very important aspect, and time is fixed, and originals are supposedly to be shown to the charge officer if he insists, because all the original copies are in the possession of the presenting officer because he represents the disciplinary authority. And after the inspection of those documents, these documents are given in the possession of the inquiring authority. So it is the inquiring authority who keeps all the original documents of the prosecution side, the department side. And when he takes those documents on record, then he has to name these documents. And how to name the document? The simple thing is to make a small square on the face of the document in the top corner or bottom corner, wherever there is a space. And the document can be named like P1, P2, P3, P4. That means prosecution document 1 or PD1, PD2, PD or PE1 or even SE1, state exhibit 1 or prosecution exhibit 1, prosecution exhibit 2. So normally whatever nomenclature department follows, so it can be followed, but it should symbolize that it is a prosecution document. So P1, P2, P3, P4, P5, P6, P10, these documents are written like that, number is written like that, and below that number, the inquiring authority or inquiring officer signs and then he puts his stamp. So a small square is made either in the top of the document, first page, or bottom of the document, and numbering plus signature plus stamp is done. And then he takes the document on to, and the inquiring officer creates a folder, that is the folder for the listed documents or the prosecution documents. So one folder is created for this purpose by the inquiring officer. So let me just say a few more things about the different kind of folders that the inquiring authority should prepare. Apart from, so one folder will be containing the charge sheet and its associated evidences, documents, etc., etc. That is the first folder that will come to the inquiring authority. One folder will be with the prosecution documents. One folder he should have for making correspondences in the entire inquiry, because he will have to indulge into several correspondences to the different custodians of the defense documents and all the controlling officers of the people, the witnesses, and the controlling officers of the defense witnesses also. So one correspondence folder he must create. One folder should be created for the daily order sheet. So what are these daily order sheets? The daily order sheets are like whenever any kind of decision is taken by the inquiring authority, he should prepare it in a daily order sheet. So whenever there is any hearing, like I told you about the preliminary hearing. So during the preliminary hearing, one daily order sheet will be created. So whenever there will be a hearing, whether it is preliminary hearing or regular hearing, and whenever any decision is made by the inquiring officer or inquiring authority, then all that decision is given in the daily order sheet, and the copy of the daily order sheet is given to both the people, the PO as well as the charge officer. So this daily order sheets is a mechanism through which what happened during the entire inquiry, I mean this proceeding, the departmental inquiry, is maintained date by date, and like all the details are there. So these daily order sheets are very helpful when you are writing the brief. Like when PO will write the brief, he will also utilize what happened during the daily or during the inquiry through the daily order sheet. Even the inquiring authority can also take straight away from daily order sheet, and he can mention that this is what happened during the inquiry. So this is a kind of sum and substance and the summary of the entire inquiry proceeding, that what happened during that inquiry. So this helps in building a case, even if suppose the charge officer is not attending and you want to go for ex parte kind of proceeding. So these daily order sheets, the details contained there help them. So this should be the part of the IO report also. So daily order sheets should be maintained very, very meticulously. Apart from daily order sheet, then you will also have one folder for the defense document, because the charge officer for his defense will need certain documents or will ask for certain documents, and those documents will be procured from the from the custodians of those documents and then given to the charge officer for his defense. Then one folder should be for the deposition of the prosecution witnesses. So whichever witnesses are deposing at the behest of the presenting officer, who are listed witnesses in the charge sheet, so their depositions have to be kept in one folder for the folder for the deposition of the listed witnesses or the state witnesses, prosecution witnesses. Then there is one more folder for the defense witnesses. So all these folders must be created by the inquiring officer in the beginning itself, so that he can conduct the inquiry properly. So there is a main folder containing charge sheet. There is a folder containing the daily order sheet. There is a folder containing all the correspondences. There is a folder containing all the listed documents for the prosecution. There is a folder containing all defense documents. There is a folder containing the depositions of the prosecution witnesses, and there is a folder containing the depositions of the defense witnesses. So somebody may ask a question that why do we need to name the documents? Why do we need to put a nomenclature like P1, P2, P3, P4? Or why do we need to put the defense documents like D1, D2, D3, D4? Why do we need to give a name to such documents? The answer is very simple. When you are writing the inquiry report, or when you are writing the either PO's brief or CO's brief, at that time, you can just write that in document P1, para number so and so, such and such fact is written. So in the place of writing that entire document, document file number, Roman 5, slash this, slash that, slash this, dated so and so, so and so. So if you take that entire documents identification number in terms of like how we normally write in the official correspondences, that please refer to your letter F number so and so, dated so and so, so and so. So that becomes a very huge kind of thing to remember also and to write it in all the places. So in place of that, just like we keep the names of individuals, like our Tyagi ji is there, Dushyant Tyagi is there, or Gaurav is there, or Mishra ji is there, or Marietta is there. So there is a name given to that document. So it is the P1, P2, P3. So you can simply write that in the document P1 or P5 in para number so and so, this is mentioned. So for the ED reference purposes, it is important to name these things, so that in the report, those references can only be written rather than writing the entire name of that letter or that file or that correspondence. Similarly, in the case of the witnesses, the nomenclature is like PW1, PW2, prosecution witness 1, prosecution witness 2, prosecution witness 3, prosecution witness 4. So whosoever deposes in the first, the prosecution witness number PW1 will come. In second, PW2 will come. Third, and the POs are having a free hand to depose the witnesses in any order, because it is not possible that the witnesses given the serial numbers in the charge sheet will be appearing in that single number only, because somebody may not be available to appear or somebody is not appearing due to any reason. So the prosecution can take a call, the PO can take a call. They can make anybody appear in any order, and they will come and they will depose in front of the inquiring authority. So whosoever comes first is taken as PW1, second PW2, third PW3. Similarly, in the case of defense witnesses, it is DW1, defense witness 1, defense witness 2, defense witness 3, defense witness 4. So in the order in which the witnesses are appearing, their numbers are recorded. Now you see how easy it will be. You can immediately say that when a question number 9 was posed before the prosecution witness number 3. So question number 9 PW3. Then what is the question? What is the answer? So you need not write the complete name of that witness in that place. That Mr. Dushyant Kumar Tyagi, Deputy Director, National Academy of Customs, during his statement dated so and so has stated like this. So it will be a huge kind of reference to be given if you are not restricting it to a kind of a number like a PW1 or PW2 or PW3, PW4. So I will say PW3 in while answering the question number 9, she has stated like this. So for the sake of easy reference, it becomes important that we keep on giving such kind of numbers to our documents and to our witnesses. So now I'll come to the inspection of the documents, prosecution documents. So when the PO has given the inspection of the documents to the charge officer, then one inspection certificate is issued by PO, which will be signed by the charge officer or his defense assistant. That inspection has been given, and that certificate is sent to the inquiring authority that, sir, we have given inspection of all the original documents, all the listed documents to the charge officer. So my job is complete. This is the certificate for that. And when then the charge officer or his defense will send a list of documents and witnesses to IO that these are the documents I want, these are the witnesses I want to depose before you to prove my innocence. So the IO or the inquiring authority or let us take IO only. So IO in that case will examine the relevancy of these documents asked for by the defense, because some of the documents asked for may not be relevant. So what can be the relevant document? The relevant document can be the document associated with that kind of misconduct. So from wherever, what is the time period of that misconduct? During that time period, the relevant file, the relevant documents available at that time are the relevant documents. Or suppose when inquiry is being conducted, some reports have been sent from there, that can be the relevant document. Or the statements of the witnesses at that time, which has been taken on record, or so that is the relevant document. So the inquiring authority will apply his or her mind, and will understand how it is relevant. Because when the the charge officer or the defense assistant on his behalf submits this list of the defense documents, he are also expected to mention that how it is relevant for this inquiry, and then secondly, who is the custodian of this document. So two things. Relevancy has to be mentioned and the custodian of the document is to be mentioned. Similarly, in the case of witnesses, defense witnesses, so the relevancy of the witness has to be given, and who is the controlling officer of the witness should also be given. So when this request comes to the IO that these are the defense documents being sought by the charge officer, then one daily order sheet is prepared by the IO, and in that daily order sheet, depending upon the relevancy of the document, he will strictly order that I find that these documents are relevant and should be provided to the charge officer, and these documents have not been found relevant. So whichever documents have been found relevant, the inquiry officer will start a correspondence with the controlling officers of that, with the custodians of those documents, and will send a letter that please submit an authenticated or certified copy of these documents so that this can be given to the charge officer for his defense. So this way, suppose uh, the charge officer has mentioned 10 or 15 documents for his defense as a defense document. So in that scenario, every document will be examined by the IO, and then in the daily order sheet, he will pass an order that out of 15, suppose either all the 15 are allowed, all 15 documents are allowed, or he has allowed 10 document or 12 document or 13 document because he has found it relevant. Those reference document which has not been found relevant, or suppose which is a document already in the public domain, then it is not controlled by any custodian as such. So they can simply say it is already in public domain. So I accept it as a defense document, but you can just procure it from the public domain and bring it to my notice or bring it as a defense document. So all the depending upon the relevancy, the daily order sheet has to be issued, and the copy of that daily order sheet goes to the PO and CO both, and based upon the acceptance of the relevancy of the defense document, the custodians of those documents will be written that please provide a copy of the certified copy of these documents to the charge officer at the earliest. And even PO, the presenting officer, is advised to follow up with the custodians of these documents so that it can be provided to the charge. While inspection of the listed document, because the originals are there, due care should be taken so that charge officer is not able to either mutilate or kind of damage those documents. It is very important care, because sometimes what happens, that is the only original thing there in the custody of the PO earlier. So charge officer may simply take those documents and tear it or damage it or destroy it. So whenever any instruction is to be given, so this care has to be taken so that it is not destroyed, it is not damaged. So that is very important. Secondly, when the defense documents are obtained from the custodians and handed over to the charge officer, then again a certificate is to be issued, and in which the charge officer writes categorically that yes, I have been given all the defense documents I have asked for, or which has been approved by the IO, and now I am ready for the inquiry. So once the inquiring authority, the IO, receives the certificate of both these documents, that the documents which is listed as in the charge sheet has been given and inspected, and documents cited by the defense as a defense document has been given to the charge officer, then the inquiry and the stage is set for the regular hearing to start. So otherwise, if the documentation has not been completed, then the stage is not set for the regular inquiry. One more thing I would like to mention here, why do we name it as regular hearing? Because this hearing has to be held on a regular basis, regularly. That means on a day-to-day basis. That means suppose today if I start a regular hearing, then it is not a case that today I will have the witnesses and then I will conclude and I will have next RH planned after 10 days. It is not like that. You cannot adjourn in between. So before the regular hearing starts, so these two certificates of defense as well as the listed documents have been received by the IO, then you have to write sufficiently in advance to the controlling officers of the prosecution witness as well as the defense witness, so that those people can come in time. So anybody can ask that how much time it will take to depose the witnesses every day, how many witnesses we can depose. So normally speaking, my experience is on a given day, we could have maximum 3 to 4 witnesses deposed, 2 before lunch, 2 after lunch. Or if the matter is complicated and like the witness is very, very important, then maximum 2 witnesses, 1 before lunch, 1 after the lunch. So depending upon the complexity of the case and the relevancy of the witness, either 2 to 3 to 4 maximum witnesses can be deposed. So suppose there are 12 witnesses in the prosecution side, the listed witnesses. So there are 12 witnesses, then ideally speaking, you should keep at least 4 days time in your hand for the prosecution case to come. Similarly, in the case of defense also, so if defense has 3 to 4 or 5 or 6 witnesses or 10 witnesses, so 2 to 3 days time will be sufficient for deposing those witnesses. So in a stretch, you need to have a planning for at least 7 to 8 days, 7 to 8 working days of regular hearing that is required. That is why what happened earlier, like the inquiry officer used to be busy in their own official jobs also. So, and that is what it was a major reason for delay of the inquiry conduct of the departmental inquiry. So DOPT came out with an instruction that whenever it is required, whenever regular hearings start and all, so an inquiring officer should be divested of his regular charge for 20 days at a stretch in two stretches, so that he can complete the regular hearings and he can write the report. So this is what is expected, that whenever you are conducting a departmental inquiry, suppose you expect that it will take around 10 to 12 days for the witnesses to be deposed. So this is the controlling officer of or the business authority, DA, can decide that the inquiring authority will be divested of his regular charge for suppose 2 weeks time, and then in that time his only job will be to conduct the regular hearing. Similarly, for writing the report, when the PO and CO brief have come, again he can be divested of the regular charges for around 2 weeks time. But in this time, we will write the report and submit the report to the disciplinary authority. So this is what has been planned. So now I have given you a fairly good idea that how many days we need to keep in our hand for regular hearing. So regular hearing has to be conducted on a daily basis. There should not be any break. There should not be any kind of adjournment to be given in between. And you have to give sufficient time for the witnesses to be called on at that station. So which station to be decided, that where do you want to conduct the inquiry? So the normal the rule, or the thumb rule is that wherever there is a facility, where there is an office, wherever there is a maximum number of witnesses posted in that office who can come, or at that station, suppose some case is pertaining to Bombay, and suppose all the witnesses, either the defense witness or the prosecution witnesses are from Bombay only, so naturally then it will be Bombay. And if the inquiry officer is also posted in Bombay, so either his chamber or her chamber, or the chamber where the case has arisen, so that place, that can be taken as a place where inquiry will be conducted. If there are private witnesses also to be taken into account, then sometimes private witnesses say, I cannot come because I cannot apply for a TADA, and I cannot spend money on traveling. So in that situation, the inquiry can be conducted even at the local office. Suppose I had a case when the private witnesses were from Kerala. So, like all the government officers, everything I conducted in Delhi. I was in Delhi that time. But for deposition of the private witnesses, I traveled to Cochin, and then there I had taken the statements of those private witnesses. Now DOPT has come out with instructions that even you have to utilize the video conferencing facility in this regard for the deposition of witnesses. So it is not the case that all the witnesses need to travel down to the main station only. Now you can even have a video conferencing facility where the CO and PO both will agree. The witness can be at a remote location, and some kind of mechanism has to be involved that at the local location, when you have written all the deposition, somebody will take a printout of that. He can go to the local office. The witness can be called to the local office there, and the local officers there can help in getting the signatures of that witness after the deposition is over, and then he can sign, and that can be sent to the inquiring officer afterwards for the signature of the CO and PO both. So that was a very big bottleneck earlier. I remember of a case where the misconduct against the officer has happened in a high commission in I think this place in some African capital, Ghana or Accra or somewhere. And in that situation, what happened that all the complainants were from that location only, because they had complained that this officer was not granting them visa. So they complained against the visa officer, and he was asking some money for giving the visa. So that was hanging fire for a long time, because how to conduct the deposition of these witnesses, and somebody will have to travel to that place from here to take their deposition. So how will the charge officer go? How will the PO go? How will the IO go? And who will bear those expenses? So those were the concerns. Now, in today's context, all those people, witnesses, could have been called at the local embassy there, and they could have been made to depose online through video conferencing here, and the document could have been mailed to their local embassy, and they could have taken the signatures, and it could have been sent over here by post. So we need to make use of the video conferencing facility as and when required, but it is always better that the witnesses, if they come and depose in front of the IO and in front of the CO, PO, then it is much easier also for conducting the examination in chief and everything. But otherwise, also, if there is a reasonably good opportunity, people are able to see that what you are typing, what are the deposition being taken, then, and there are no objections by the PO and CO, then there is absolutely no problem. So you must devise a good method so that the video conferencing facilities can be utilized in this regard. Now, coming down to the depositions. So, as I told you, the PO is free to depose the witnesses in any order. So, whosoever comes first and whosoever has given the statement in that case, so PO will start asking those questions. So how to get the deposition done? So you will, when the IO will make a document, like he will be sitting with the secretary and assistant, or himself also, and he will open up a Word file, and on the top of that file, the office heading will be mentioned. Below that, what is this document? So in which case this statement is being taken. So you can just mention that the departmental inquiry in the charge sheet number so and so, dated so and so, deposition of the prosecution witness number 1, or you can say deposition of Shri so and so. Suppose deposition of Shri R.B. Mishra, Assistant Director, NACIN Mumbai, as PW1. So this is written there. Then below that there will be examination in chief. So what is examination in chief? So what happens is that if prosecution brings in the witness, so prosecution, the PO is supposed to ask the witness the basic questions or any kind of question to prove the charge. So it is advised. And sometimes POs fail in their role. PO should be able to connect with the witness much before he comes for the deposition. Because what happens is that PO, when the witness comes unprepared, then they are not able to answer in the proper format. Some witnesses have forgotten that incident because incident may have happened a couple of years earlier. They do not have any knowledge about that incident, and what they had said during that time when the preliminary inquiry may have happened, they have forgotten those things also. So before bringing the witness for deposition before the inquiring authority, it is my advice that the presenting officer should meet his witnesses and should make them aware about the entire case, what they have stated earlier in their own depositions during the preliminary inquiry. That should be told to them, and what are the evidences in this case should be told to them, and in fact what questions they are going to ask, even that should be told to them, so that the witness is completely prepared to answer in the way which is going to prove the charges. So this is called the witness preparation by the presenting officer. Defense will always come prepared like that. So our POs normally they fill in their responsibility because they think that the government servant will come and they will say whatever they had to say, and they should say as per their own free sweet will. I should not tell them because it will be influencing the inquiry. Your job is to prove the charges. Presenting officer's job is to prove the charges. So he has to really tutor his witnesses, bring his witnesses with complete knowledge of the entire case, all evidences, so that whenever he deposes the witness, they should be narrating the incident, or there should be giving the details, whatever is required to prove the charge. So I always suggest that PO should be prepared with the questions also, that which questions they want to ask for which witness, and those witnesses should be told about those questions in advance, and what should be the good answer of those questions should also be told in advance. So that way what happens is that it takes lesser time even during the deposition. Because otherwise, if you would ask a question out of the blue, then the witness will say, please show me that document, please show my statement earlier, please show what I had said that time, then I will say something here. So that time is not wasted. So PO has to come prepared with the entire with the questions and the witnesses, so that they take very lesser time in deposing. And in the examination in chief, PO should be asking these questions sequentially. Only restriction in the examination in chief is that you cannot ask a leading question. So somebody may ask that what is a leading question? So the leading question is that where the answer of a person can be in yes or no. So let me just give you an example. So if I ask a witness that on such and such date, where were you? Suppose the witness was in Surat, suppose. Then he will say obviously that I was in Surat on that day. And what is the leading question? Leading question is that, Mr. So-and-so, on such and such date, were you not in Surat? He will either say yes or no. So if the answer is coming as yes or no, that means I am trying to lead the witness. So I am telling him that you were in Surat, you accept, and you say yes or you say no. So in the examination in chief, the leading question is not allowed to be permitted. And if some PO asks the leading question, the charge officer or the defense assistant can object to the inquiring authority, and they can say that, sir, he is asking a leading question. Then the IO can tell the PO, please don't ask leading question, please rephrase it. So then the PO will rephrase it. So PO should come prepared with his list of questions. That list of questions should be a little typed out, or he can have a document and he can ask those questions. That question will be written down by the secretarial assistant or the IO himself. And then whatever answer is given by the witness, that answer is verbatim, recorded verbatim by the secretary assistant like PS or the IO who is taking the inquiry, verbatim. The answer should not be changed at all. This is my advice. Whatever is being stated by the witness, it should be written, recorded for that. So then suppose the examination in chief continues for the witness. Suppose the IO is, PO is asking questions. Suppose he has asked 10 questions, 12 questions, 15 questions, whatever. Because he will try to prove the charge from various angles, so that the witness's deposition is interconnected with the various other documents, various other witnesses who have to come and depose, so that the fact can be rather triangulated, so that one can say that, see, it is not independently he is saying something. This witness is saying something which is having a backing of certain documents here, which is also endorsed or will be endorsed by the other witnesses here, so that the fact, this is the fact I want to say. So after the examination in chief is over, then the witness is handed over to the defense for the purpose of cross-examination. If any witness is not handed over for the cross-examination, then the relevancy of the witness is not there. Then that witness's deposition doesn't stand the test of the procedure or the law. So once the examination in chief is over, witness is handed over to the cross-examination for the cross-examination to the defense assistant. Now the defense assistant will keep on asking all sorts of questions during cross-examination, and it may be a leading question, non-leading question. He may try to confuse the witness also. So it all depends upon the person. What is the level of his cross-examination skills, and they may try to come out with the complete facts. So suppose if the witness is lying, then that lie must be caught by the cross-examination by the defense assistant. So even the defense assistant's role is very important, because you will get that witness who has come from the prosecution side only once for the cross-examination. It is not a case that you will keep on calling for that witness again and again and again. It's not the case. He will be offered to you for cross-examination purposes only once, normally speaking, until unless it is very important that the witness should be called again. Normally speaking, they are not called again if he has been offered with the cross-examination. So what happens is that the defense assistant should come prepared that prosecution will be bringing these witnesses. These witnesses' role is like this and this. So I need to counter question him on such and such points where the deposition, I can prove that the deposition was wrong, or the witness is not telling the truth, or this is the truth. Because it is the job of the defense to defend the charge officer. Either the charge officer himself will ask those questions, or the defense assistant will ask those questions on the behalf of the charge officer. So just like a defense lawyer, he has to prove that whatever is being stated is completely true. One more thing I would like to mention here. It is not the case that the charge officer has to prove his innocence. Department has to prove the charges against a person conclusively. So the burden of proof is not on the charge officer, but on the presenting officer, on the department, to prove that these charges are sticking. So if there is, even if there is a minor case, or there is a minor issues, or there is a kind of a relief that the defense can seek by the cross-examination of the witnesses, and they have got the loopholes, and they can come in the realm of like the charges are not getting proved conclusively. So then that they will get a relief out of this. So cross-examination is also a skill. That is why the defense assistant has to be like a very trained kind of a person in the laws, and he should know the art of asking the relevant questions, even to that extent leading questions, so that he can nail down the bogey of the prosecution witness. In this stage, somebody can ask that whether the defense assistant can be a lawyer. So in this case, the provision is there. Normally speaking, the defense assistant should not be trained in law, because defense assistant is normally a person who is in the department itself or retired from the department. He had just come to help his friend, or he can also help professionally also. There is no bar in that. But he cannot be a lawyer, normally speaking. He can have a law degree. If he is a law degree, then he can be allowed as a defense assistant only when the presenting officer also has a name. Otherwise, what will happen? Here in this case, there is an officer having a good backing of law. He knows the law too well. He has a law degree, a lawyer. And on the other hand, the departmental presenting officer is not having a law degree. It will not be having the level playing field. So, normally speaking, we allow the defense assistant to be a person who is working in the same formation or nearby the same station, and having a sufficiently good number of good experience in that good matters, business matters, and the departmental procedure matters, to defend his friend or known person over this. So after the cross-examination is like over, and suppose the defense assistant has been able to confuse the witness, then the presenting officer can also request the IO that these are the points where perhaps the witness has been confused by the defense. I would like to clarify those matters, and please allow me re-examination. So in that case, the PO will be allowed a re-examination only on those parts where the witness, out of sheer confusion, have stated something different, which was not the fact. So limited number of questions can be asked in the re-examination. So in a deposition of a witness, prosecution witness, 3 stages. First stage is examination in chief. The second stage is cross-examination, and the third stage is re-examination. So after all these things, 3 stages are over, then the deposition of that witness is over. So then it will be concluded, and in the bottom, a witness will sign, and again in the bottom, CO, PO, and IO will sign. It proves conclusively that everything has happened in front of the IO, in front of both CO and PO. So nothing should happen at the back of the charges. So that is very important, because all the witnesses need to be deposed, because you have to examine the examination in chief, then cross-examination, then re-examination. And what should be the like stand of the inquiring authority in this entire process when the deposition is happening? What is the stand of the inquiry officer? What is his role? His role is to only be there, alert, and see that the depositions are happening in a proper format, and it is not the IO who will be asking even a single question in the matter. Many cases I have seen that IO has taken down the mantle of the PO. IO has been very, very enthusiastic in proving the charges. IO is more than acting, well, IO should be acting in a neutral fashion, because IO's job is to be a judge. The facts are being presented before you from both the sides. You are just a kind of arbiter. You are just a judge. You are not working from the side of the presenting officer or from the defense side. You should not also appear to behave in that fashion. So no questions asked. Not a single question will be asked by the IO in the entire deposition. Only when the examination in chief concludes, then he will say that defense assistant that now you can cross-examine, and when he cross-examines, then if the PO says that I want to re-examine, then he will allow him to re-examine. Then all the documents will be typed properly in front of him. He will ensure that the depositions are taken verbatim, and then they will take a printout of it and they will sign everywhere, and then that thing is complete. And in the daily order sheet, it will be mentioned that today, on such and such date, when the regular hearing started, such and such person, designation such and such, appeared for his deposition. He had been named as prosecution witness number 1, PW1. During deposition, he was asked 15 questions in cross-examination, so many questions in the so many questions in the examination in chief, so many questions in the cross-examination, so many questions in the re-examination. His deposition runs into 3 pages, 4 pages, 5 pages, whatever number of pages. So all that is to be mentioned in the daily order sheet. Now there is one very important point here. What happens is that, suppose one witness, which is a prosecution witness, he comes. Just 1 second. So just like this prosecution witness number 1, all the witnesses number 1, number 2, number 3, number 4, number 5, number 6, number 7 will be deposed before in the inquiry, and all the witnesses will come one by one in any order, and they will depose before the inquiring authority. And the same procedure, on the examination in chief, cross-examination, and re-examination, and conclude. One thing I would like to mention here is a practical aspect. So I had said earlier in my session that whenever we conduct a preliminary inquiry, so there will be inquiry officer there. So whosoever has done the preliminary inquiry, that vigilance officer or anybody, should also be listed as a witness in the charge sheet, because he is the person who knows the entire case very, very well. So normally speaking, that inquiry officer who has conducted a preliminary investigation inquiry, he should be deposed the last. He should be the last witness of the presenting officer, because in the entire deposition, the PO will see that which witnesses have said what and how things have gone, where are the loose ends in this inquiry, and those loose ends are to be tightened to this inquiry officer, who conducted the preliminary inquiry. So departments make a mistake many times. What happens? They try to prove the case conclusively based upon the primary evidence, that is only the documentary evidence. They sometime in the charge sheet do not have any kind of witnesses, and due to this, sometimes, since there is no witness, some courts have given adverse, judgments that then how do you prove the case if there are no witnesses? So my point is that even if you are able to prove that the charges documentarily, you must have one or two witnesses at least. And if no one, then the inquiry officer of conducting the preliminary investigation should be cited as the witness. So even if there is one witness, that is sufficiently more than enough. Now, through this witness who has conducted the preliminary investigation, he knows the case like the back of his hand. He knows the case too well because he is the person who has given the report earlier also. He knows from where, which document, what has been taken and what has been said and how the case is proved. So he should be the person who will be deposed the last. I will say one more thing. Suppose the case was based on some DRI investigation, or the case was based on some other investigation, some DDGI or other investigation, where the role of the departmental officer also surfaced. So that DRI IO can also be named as a witness in this departmental procedure, because the DRI IO knows the case too well. So now if you call the DRI IO and he is deposed the last, he will be able to tie up all the loose ends in this entire deposition which has happened before the inquiry officer. So one witness at least is must, and if you have only one witness, then that should be the inquiring officer who are either in the DRI case or in the preliminary investigation, whosoever it was, who cite that person. You can also cite two, DRI IO 1, and from the vigilance side, who was the IO who conducted the preliminary investigation, second. So then two witnesses in this case. So both the witnesses will prove the case conclusively in this. So this is how the depositions are done. Now, if there are private witnesses, I mentioned use as much of video conferencing facility as you can. Now, two kinds of witnesses are there. One is the government servant and other the private witnesses. Suppose in the CBI case, when there are so many private witnesses also, the government servants also. So government servants, government witnesses are not supposed to deviate from what they have said earlier during the preliminary investigation time. So whatever statements have been given by the government servant at that time, they should stick to that line only today also. But sometimes what happens is that government servant also, they also, suppose somebody is retired. So then they start thinking that unnecessarily due to me, this person is going to be stuck. So then they try to change the version. So whenever any person tries to change, even if a serving government servant, they can be charged again for giving a wrong statement or being a hostile witness. We call this thing being hostile witness. That earlier I had said something different, now I am saying something very different. So if something of that sort happens, the presenting officer should at least stop and say to the inquiring authority that, sir, this witness has become hostile. I do not want to take his examination in chief any further, and now please offer him for cross-examination to defense, and please offer him for cross-examination to myself also. So hostile witnesses should then be cross-examined. Hostile witnesses, the moment a witness is declared hostile, at that moment only his deposition from the prosecution side will stop, and then he will request, PO will request the IO to offer the witness for cross-examination. So this is how it goes. Similarly, if the officer is a serving officer, then PO will be writing to the concerned controlling officer that this person has deviated from the statement he has made earlier, and for that, suitable disciplinary proceeding can be initiated against that witness. This is how the prosecution deposition of witnesses go. Now, when all the witnesses are deposed, so then the prosecution case ends. So at the end of the prosecution case, there is a mandatory requirement that a written statement of defense has to be taken from the charge officer at this stage also. So IO tells the charge officer that now the prosecution case has ended. Do you want to admit any charges now? Because now you have seen all the evidence in front of you. You see, you know how well you can defend. If you admit any charges, then it is fine. Otherwise, you will lead your defense further. So this written statement of defense is to be taken at this stage from the charge officer. Normally, what charge officer do in this case is that they will simply write one paper, a couple of lines in that. At the end of the prosecution case, having deposed all the witnesses, still I do not admit any charges, and I want to lead my defense through my own witnesses and documents. So the point is, at this time, just a requirement, but if somebody misses this requirement, then again what will happen? It will go to the court or the CAT, and then CAT will say that procedure is not followed. So this is a mandatory step. One more thing I would like to mention here, right? Whatever has been admitted as a defense document, so it is not the case that PO will not be asking questions regarding those defense documents from his own witness. It is expected from the PO that once he will complete the case, before he completes the case, even those defense documents he can question, and he can show it to his witnesses, and he should anticipate that what is the benefit the charge officer is looking for from such defense document, and that benefit should be, that balloon should be busted right now only during the prosecution, witnesses depositions, because he will not get this opportunity when the defense witnesses start. Defense witness will not be at his dictation. They will be trying to defend the charge officer. So whatever document has been admitted as defense document, PO should be able to read those documents and should try to understand that from where the charge officer is coming and what documents, what benefits he wants to take from these defense documents, should anticipate those issues, and while he is deposing his own witnesses, should be able to take those issues also straightway, so that he is able to nullify the advantages of the charge officer in his own witnesses deposition itself. Okay, so now the prosecution case ends, then the written statement of defense is taken from the charge officer, and as I mentioned, they normally say only one page. Only one pager is given that still we do not agree with any of the articles of charge, and I would like to lead my defense through my own witness. So that is taken on record. So that is the written statement of defense. Even a folder should be made for this. So this is also important folder, and the document should be there. Then the IO allows the PO, the charge officer, to present his witnesses. So now the role is changed. So defense will bring in witnesses as per the order they want to bring in, and now the defense assistant will be asking the questions to the witness and examination in examination in chief. So here again the document will be made that office heading, then the charge sheet number and against whom the charge sheet is there, then the deposition of the defense witness, name so and so, posted as so and so, so and so, and then DW1, defense witness 1. So again, the defense assistant will be starting the examination in chief. Then he will ask certain number of questions. Then he will offer that witness to the PO for cross-examination. So now the PO should be smart and he should be able to ask the relevant or the tough questions during the cross-examination to this witness. And again, he can also get this witness confused. So in that scenario, the defense assistant can ask for the re-examination as done in the case of PO. So all the 3 steps, 2 steps mainly, 3 steps even when needed. So examination in chief, cross-examination and re-examination. That will happen with the defense witnesses also, and then the depositions will be concluded. So one after another. Suppose defense has produced 5 witnesses or 6 witnesses. Then all the 5, 6 witnesses will be concluded in a similar fashion. As I said, maximum 2 to 3 witnesses one day. So 2 to 3 days it will take before the entire defense witnesses are concluded. Again, IO's role is to only be there, listen to the depositions patiently, and do not interfere into whatever is happening, except if the things are getting out of order. In a very heated discussion, if there hurling of abuses among the PO and CO and witnesses, those things should be avoided. He should just make sure that entire process goes in a proper parliamentary and sanitized fashion, so that nothing of this kind of ruckus is created during the inquiry. After the defense witnesses are deposed, now this is a very, very important thing. Now the charged officer will be asked by the inquiry officer whether he also wants to become his witness. So what is the meaning of that? If the charged officer wants to become his own witness, that means he will again depose as a witness. Then he will also be asked certain questions in examination in chief, offered for cross-examination and then re-examination. So normally speaking, what happens is that a charge officer does not want to become a witness, because if the PO is smart, he will ask so many questions in the cross-examination, then he may get stuck. He may not be able to lead his defense successfully. So normally speaking, a charge officer does not become his own witness. So this stage is important. The IU has to ask that, do you want to become your own witness or not? If the person refuses, then the charge officer will be examined by the inquiring authority IU. So this is the only time, please mark my words carefully, this is the only time when IU will be asking certain questions to the PO. Now the question is, which question he will ask? What questions he will ask? So IU is supposed to maintain a close monitoring on whatever is happening in the entire depositions. And like a judge, he should be able to understand that where this charge officer's defense is not successful, where he is getting stuck. So he should know that these are the points which is the weak point for the charge officer. So to ask clarifications or to give him an opportunity to defend on those weak aspects, those weak areas, or to clarify it properly, the IU should be asking certain number of questions to the charge officer. This is the only time. So this is called general examination by IU. This is contained in Rule 1418, Sub-Rule 18. So it's a very important step. A lot of inquiry officers miss this step, leading to benefits from the CAT when the case is again remitted back for re-inquiry or from that stage. So it further complicates and unnecessarily puts a lot of burden on the entire process. So, as I have said earlier also, that the process has to be followed literally. So, this step of 1418 is a very important step, and anybody and everybody who is an inquiring officer or a PO, you must make IO aware about that, or IO should be knowing about it, that I must general examination of the charge officer is must. So normally speaking, what happens? Whatever questions IO asks, if the charge officer wants to clarify those answers, those questions, he is well within his right to do so. But what is my experience is this: the charge officer always say whatever questions IO asks, the charge officer say, I will give my submit my defense to my defense in my charge officer's brief, my defense. So he does not want to absolutely clarify his defense at the moment, because when if he is clarifying his defense properly, what will happen? This will be documented. Then in the PO brief, PO will again try to negate or nullify these arguments. So sometimes as a strategy, the charge officer does not want to disclose his entire defense. So sometimes he will say, well, even when the IO is generally examining the charge officer, his statement is only simple that I will submit my defense during along with my defense brief. So he simply says that, so it's a one-page document again. But this step is very important. So all IOs should definitely remember this. They should not forget this, that I need to generally examine the charge officer on under Rule 1418. Now, just to say one more thing. Earlier, there were instructions for the IO to conclude the departmental proceedings within 6 months, departmental inquiry within 6 months. From the date of appointment, from the date of receipt of the appointment order, and from the date of submission of the IO's report. So maximum time is 6 months. So it was earlier part of the instructions. Now what they have done is that it has been incorporated as a rule. So under Rule 14, Sub-Rule 24A, they have clearly mentioned that now within 6 months only IO will have to submit it. And then there is 14 Sub-Rule 24B that says that maximum of 6 months can be extended on clearing proper reasons that why the inquiry is not getting completed within 6 months time. For another 6 months is given. So at the most 1 year time is available for the IO to conclude the inquiry. And what happens is that people keep on taking long time. I do not understand, if we go in a systematic fashion, why should we take more time in concluding the inquiry? If you know about the things properly, as I mentioned earlier also, you now anybody who has been made IO and PO should take that course on iGot Kavyogi portal. That's very important. They have given all the steps there, and they have mentioned everything. Apart from that, you need to read the CCA rule. You need to see the handbook of procedures issued by the DOPT, or you can consult any book that gives the various stages of the inquiry. So one must be completely informed before one starts an inquiry, and one should not start behaving as if it's the case of an elephant and 6 blind men, that they do not know how to do, what to do. Somebody is saying it is like a leg, somebody is saying it is like a trunk. So that is not the case. You should be completely informed about the different stages of the departmental proceeding and how to conduct it and how to conduct the inquiry. So now I have mentioned all the steps how to get the depositions done for the prosecution witnesses, for the defense witnesses. After the case of prosecution ends, then at that time we have to take the written statement of defense, and when the defense witnesses are deposed, then in that case the IO must ask the charge officer whether he wants to become his own witness, or whether he, if he doesn't want to become his own witness, then he will be examined generally by the IO. And then with that, the regular hearing concludes. Afterwards, the IO gives the PO 15 days time to submit the PO's brief. So the PO's brief is submitted in duplicate, 2 copies. One copy comes to the inquiry officer and one copy is extra, which the IO needs to send to the charge officer. And that after that, the charge officer is requested to submit his brief within 15 days. So he also submits in 15 days, and then after he receives the CO's brief and the IO the PO's brief is already there, then within 15 days time, IO is required to submit that his report to the disciplinary authority. So how to write that report will be discussed in the next session of the Vigilance Dialogue. Here, briefly speaking, I will just mention 1 or 2 points, that if there is an allegation of bias against the inquiring officer, so in that case, what should be done? So whenever the charge officer raises a kind of allegation of bias against the inquiry officer should stop the inquiry and then should refer the matter to the disciplinary authority. The bias has to have certain kind of basis. Some reasons must be mentioned by the charge officer. It is not the case that I don't like the face of the inquiring officer, so please change me. So if there is an allegation of bias, the bias has to have reasons for the bias. And what are the issues on which you think that inquiry officer is biased? And then the disciplinary authority is expected to apply its mind and dispose of that allegation of bias within 15 days by issuing an interlocutory order. So they will pass an order and they will nullify or they will accept the bias, or the bias is not there, and they can direct the inquiry officer to take the inquiry further. So normally speaking, if the bias is pre-existing, suppose like the IO was such that he was posted as a boss to the charge officer and they did not have good equation, and there is a previous history to the entire thing, or the IO himself was part of the formation where all this thing has happened under his nose, so he is a bias in that case. So that is why inquiry officer has to be chosen in such a manner that he is an independent officer who has not dealt with these files and who has not been the bosses of the charge officer earlier, and who has got no personal grudge against the charge officer. And he should be independent, and he should also appear to be independent during the entire, independent and fair. He should not have any kind of preconceived notions. Not be asking questions like PO, and he should not be seen to be a person that he is hell-bent on proving the charge. So you have to maintain that kind of posture before the charge officer, that you are not biased in anything. So in any case, if the allegation of bias comes, it is referred to the disciplinary authority, and DA is mandated to issue an order in that case within 15 days time. And normally speaking, DA issues an order that bias has got no basis to sustain because the allegations are not sustainable or the evidences are very weak. And then in that situation, we can direct the IO to continue with the inquiry procedure. So that then the inquiry again starts. So normally speaking, if you plan well, regular hearing will end in 7 to 10 days time, and then you can write the report lately afterwards in 7 to 10 days time. If required, if your workload is heavy, the DA can divest you from that regular work, and you can focus only on that inquiry for 15 days time. This is how we need to conduct the inquiry. If we go systematically, there are absolutely no issue in conducting the inquiry. Now, in the next session, I will discuss about how to write the inquiry report. Now, I will request all the participants that if they have any kind of queries, if they have any questions to ask regarding anything, they are most welcome to do so. I open the floor for all discussions.
Thank you, sir. If any officer, they have any questions, you can please raise their hand or they can put in the chat box.
Please come with any question, whatever you have, even if it is very silly also, doesn't matter. Anything, any doubt should be clarified.
So one thing I would like to mention, I was given an inquiry, and I initially in the initial years, and I was struggling so much how to write a daily order sheet and all the steps you have told. So I think probably if I could get that kind of session or insight, I would have made it better. So I think today's session being very wonderful, and what I personally feel is it has clarified so many doubts.
Thank you so much. Anybody else with any observations? वर्मा जी कुछ बोलना चाहते हैं? आपका म्यूट है, वर्मा जी म्यूट है.
Please unmute yourself, VK Verma. Please unmute yourself. You're
Yes,
muted.
Sir,
Yes,
thank
now.
you very much for your visual words, and we have been enlightened. Thank you very much, sir. बाकी पार्टिसिपेंट्स को कुछ भी डाउट्स हैं तो क्लैरिफाई कर सकते हैं.
Hello. Good afternoon, sir.
Yes,
Ravinder Kumar from Ahmedabad, Superintendent.
Go ahead.
Sir, my question is that in one case, a charge officer has been issued a charge sheet, and after issuing the charge sheet, the charge officer has submitted his statement of defense. Now, in the statement of defense, he submitted 2 more documents, and all these documents, along with the charge sheet, copy of charge sheet, has been has been given to IO and PO. Now, during the entire inquiry, IO and PO, basically PO has not examined those documents which the charged officer has given at the time of statement of defense, citing the reason that he does not have any mandate to go beyond the charge sheet. Whatever documents and witnesses mentioned in charge sheet, he will only examine those documents. Now the entire inquiry has been done, and IO has given his inquiry report saying the charge is not proved based on those documents only. And now we struck that these documents have not been examined or cross-examined by IO or defense assistant, but IO has given his report on the basis of those documents only. So what could be the way out in this case, sir?
My point is that once these documents were given, they should have been made into a different documents.
Yes, sir.
The charge officer should have requested that these documents should be made into defense documents. And the moment
Yes.
it is made a defense document, then that document would have been considered. So now
Yes,
I am amazed to listen that even though the IO did not consider those documents, despite that the IO has said the charges are not proved.
yes, sir.
Okay, very good. So that means the charge sheet must have been very, very weak otherwise also. So then what is the problem right now? If the IO has not considered
Yes,
those,
sir.
and the charge officer doesn't have any issue on that because either he would have made the different document, the charges
Yes,
are
sir.
proved. So
Yes,
then what is the problem? What is your problem?
Basically the problem is that when the IO has submitted his report as charges not proved, and we have submitted to DGOV for second stage advice, at the time of second stage advice, DDOV is telling that these documents have not been examined or cross-examined. So the matter is stuck, although disciplinary authority agrees with the IO's report and has given in favor of the charge officer only. But DGOV at the time of second stage advice is pointing these observations.
The point is like it was the PO's job to question those documents.
Yes, sir.
Perhaps see that is why sessions like this is important, because people do not know. Even the charge officer does not know, the defense assistant does not know, even the PO does not know, the IO does not know. So
Yes.
they should have simply taken these two documents as defense documents. And then the
Yes.
PO should have also cross-examined about, I said nothing, when the prosecution witnesses are being deposed, at that time the defense document should also be questioned. Because PO needs to understand at what benefit this person will take from these documents. Okay.
Yes.
DGOV's point is also very, very relevant. That
Yes.
you are basing your entire argument on that, and that document was not questioned by PO, then there is a failure on the part of the PO also.
Yes.
And IO has definitely failed to some extent.
Yes. Yes.
Now, what call they will take, it is for them. I can't comment on that. But that is why such platforms are required. That
Yes, sir.
to clearly understand what is to be done.
Yes.
Next question, please.
Sir, I have another question. Sir, I don't think so. It's very relevant to this this one. But my question is, during the time of suspension, should the suspended officer needs to come to the officer and mark his attendance regularly? Because right now biometric attendance is going on. So is it his mandatory to mark his attendance?
During suspension, he is not supposed to mark his attendance because he is suspended, because the very fact you have suspended the officer is that for the simple reason that he should
Yes.
not be seen in the office,
Yes. Yes.
that he does not tamper with the evidences,
Evidence. Yes.
not be able to influence the witnesses in this thing. So
Yes.
he should not be coming to office, but his station has been mentioned that he will be attached in this station. So he should
Yes.
remain in that station, because whenever he is required to come for any investigation and inquiry, then he can immediately come. He cannot claim that since I was not in that station, I will claim DA, TA, DA to come to that station. This is how things are. So
Yes.
during suspension, an officer is not supposed to be in the office.
Yes. Yes. Thank
So
you so much.
So, thank you, Ravinder. So, one question is posted in the chat box.
Yeah.
In many inquiries originating out of CBI investigation, CBI officers are made prosecution witnesses. However, they do not appear for examination, and this works in the favor of CO. Should IO then rely solely on CBI investigation report? Or can IO call for any document which are not made RUDs in charge memo?
Yeah. So in this regard, my suggestion will be that out of several CBI officers cited as witness, okay, the main IU of the CBI who did the main investigation, he should be called. At least he will be able to tie up the entire evidence in a proper sequence. So actually for everything, they managed to put a name, that who will record the thing, who will go along with this, who has done the authentication. So there are so many witnesses that because it helps their case in the court of law. Suppose it's a case of like a trap. So in the trap case, then every person's role is important, and then the court where the trial will take place, all those witnesses are important, and they will all be attending there. The departmental proceedings, they may not come. So at least the IO should be requested to, or he should be brought here by the PO, and then he will tie up all the ends. So even his statement will be sufficient enough, because the departmental proceeding, the proof is of preponderance probability, not reasonable doubt. So the reasonable doubt thing in the court, that is very important. So even IO comes, then it is going to be fair enough, not a problem.
So next question is,
You know, that is why sometimes it is important that wherever CBI has filed a charge sheet in the court of law, in the special court of CBI, so only on that aspect, department should not give a charge sheet, or department should give a charge sheet and then they should wait till the time what happens in the trial that is taken place, or department should give a charge sheet on the other aspects. Suppose it's a case where you have got a trap case, or where it is a disproportionate assets case, then in the DA case, the CBI will be fighting that case in the court of law. Then department should give charge sheet on basis of like non-submission, like non-intimation of certain properties. So those things should be there in that departmental charge sheet. So that can be proved very, very easily independently also. So normally speaking, on the criminal aspects where CBI has taken the officer to the court, the departmental charge sheet should leave those aspects and take the other aspects where the CBI has found non-prosecutable evidences and where other departmental conduct rules and other things have been violated. Yeah, next question. I think one more. ADC Zone 3 has raised a question. Please go ahead.
ADC Zone 3 would like to ask on their own.
Yeah, she was there. Please come again. पूछिए. Okay. So
Okay, I'll take up the question, sir. Can IO call for any documents which are not made RUDs in charge memo?
See, IO can always call for document which is not there in the charge memo if that is requested by the charge officer, because that is a defense document. So that defense document they can always ask for. If the CEO has asked that I want these to be defense document, and if the IO allows that, so it will come. Okay, but on its own, IO has to just maintain a just like posture. He is not a person to prove or disprove the charge. So it is the case of PO or CO to ask for any document to be produced before the IO or not. So that is how it should go.
So there's a question by Anil Kumar. Anil Kumar, would you like to ask on your own? Okay. So I'll just ask. If any officer is punished under major penalty, then up to what time he or she will be kept in cloud list?
See, at least up to the currency of the punishment, he will definitely be. In the time the punishment is going on, he will definitely be, or she will definitely be in the cloud list. Then what do you mean by the cloud list? What is the cloud list? One more thing is there. Suppose a person is looking for a deputation in some other ministry or department. Then as per the DOPT circular, the person cannot go on deputation. Suppose somebody has been awarded a major penalty punishment. So from the date of completion of the currency of the punishment up to 5 years, he cannot be considered. If it is minor penalty case, up to 3 years, he cannot be considered. So that is for the selection posts, but will not be applicable for the promotions and other things. So cloud list, there is no meaning of cloud list as such. But if you are going for deputation, then they may not be entertaining your application up to 5 years or 3 years, because they look for 10 years history. You will not be selected. Departmentally, if the integrity of a person is compromised once, then either you keep him in a cloud list or not, but you have to always keep an eye on the person. But let us not keep the person in any kind of list as such, but overall, he requires supervision. Next, please.
Once the adjudication is done and a major penalty imposed, is the officer eligible for the reimbursement for deducted salary when he was suspended?
No, but like since his suspension has not been regularized, so whatever subsistence allowance he has got, that is the only thing he is getting. He has not worked. So since he has not worked the department, no work, no pay. So whatever subsistence allowance has been given by the department, that is good enough. Next question.
Sir, any other question? I hope. If anyone has any question, please raise your hand.
So may I ask?
Yeah, please go ahead.
Good afternoon, sir. This is Ashish Rawat from Mumbai Custom Zone 1, sir, Superintendent.
Yes.
So one thing I wanted to clear that, sir, you said that whenever charge officers objects that IO is biased, so in that case, whenever the new IO comes, so the proceedings will start afresh, or he will be given 6 months new time, or it will be continuously after that the proceedings which have taken place.
See,
Thank you,
Ashish,
sir.
normally speaking, the allegation of bias hardly succeeds. Because when the posting of the IO is being done, so at that time only they look into everything, okay, and then they are not posting anybody who is connected with the case or who has been the boss of the charge officer. And so that IO is independent. But if during the conduct of the inquiry, suppose it appears that the IO is behaving in a very, very biased manner, he is not entertaining anything. So normally speaking, the new IO will start the inquiry from the place from where the ex-IO has been taken out. So from the same place, he will start conducting the inquiry. And the 6 months will continue.
Right, sir.
Okay, Ashish?
Thank you. Right, sir. Thank you, sir.
Anybody else wants to ask any question now?
So if there are no other questions, so with your permission, can we wind up the session?
Yes, yes,
Uh,
yes.
But sir, not before I express my gratitude and all the participants for your insightful and informative online session explaining the roles of the inquiry and presenting officers and officer defense assistant in such an elaborate and easy to understand manner. Your expertise and clarity in presenting the material made it so much easier for all of us to grasp the intricacies of the subject matter. We'd also like to thank our participants for being attentive and for your queries, making the session an interactive and interesting one. I would like to end with a request to all of you to please join in next Tuesday for another session in the Vigilance Dialogue series. I would also like to add that for those of you who have missed any session earlier or would like a recap of the current one, we are uploading recordings of these sessions on the NACIN YouTube channel. So you're requested to please log in. So with that, thank you once again and wish you all a good day. Thank you.
Sir, you are muted.
Thank you, sir.
Thank you, sir. Sir, Prabhat sir, you are muted, sir. Unmute, sir.
Thank you, everybody. So should we close down the session now?
Yeah, yes, sir.
Right.
Thank you, sir.
Thank you, sir.
Yes, sir. Thank you so much.